Good evening, everyone. My name is David Van Zandt. I'm the dean here at the New School, and I want to welcome. Excuse me, Dean. I'm sorry. I did it for far too long. I've been president. I am president of New School, so unless somebody, maybe I got demoted recently. I don't know. A special welcome to all of you, but also to our moderator, Ken Roth. I've known Ken for quite a few years, having been in law school with him, and we couldn't have a better person to moderate this discussion. I also want to thank Ariane Mack. She is our Alfred and Manette Merrill Professor of Psychology at the New School for Social Research. Many of you know her very well. And she is a bundle of energy. She puts on spectacular programs, and she's a real asset to not only to the New School, but also to the New York City community as well. And I'd also like to thank Henry Jarecki. I don't know if Henry is here tonight. Yeah. He's helped to make this event possible. He's the vice chairman of the Institute of International Education, and he's the founding chairman of the Institute's Scholar Rescue Fund. Tonight's discussion is the fifth in the Center for Public Scholarship's Public Voices series. The series brings together distinguished speakers to address pressing issues of the day. Our previous programs have included Steven Pinker and Robert J. Lifton on violence, Nicholas Eberstadt and William Galston on entitlements. We had Russ Feingold on institutional failures after 9/11. And our last one was Barney Frank, speaking about military spending. Tonight's topic is especially timely given recent press about the U.S. government's activities to monitor electronic communications. Are the restrictions placed on electronic surveillance really adequate in being applied? And how do we strike the right balance between the needs for safety and the right to privacy? I'll now turn it over to Ken Roth. Ken is the executive director of Human Rights Watch, which is one of the world's leading international human rights organizations, which operates in over 90 countries. Previously, he was a prosecutor in New York and for the Iran-Contra investigation in D.C. He's conducted numerous human rights investigations and missions all around the world, and he's written extensively on a wide range of topics on human rights abuses, including counterterrorism, foreign policies of major powers, and international justice and the work of the United Nations. So Ken, again, thank you for doing this. It's great to have you here, and I'll turn it over to you.
All right, well, thank you very much. Well, thank you, David. It's good to see you again. And it's a pleasure to be here at the New School. Ariane, you're doing a real service by bringing us together to discuss this issue that I think we all have a sense of disquiet about. But it's a complicated issue. And what I hope we will do today is gain a better understanding of where this disquiet comes from. You know, what is the history that brings us to this moment? What are the laws that clearly are inadequate in constraining the U.S. government's surveillance? And what exactly does this vast agency, the NSA, or some of its governmental partners do with these massive amounts of information that, thanks to Edward Snowden, we now learn that it is collecting? So these are among the issues that we're going to explore this evening, and we have a great panel here to help us do that. I will introduce each of them now, and I've asked them each to talk for 5 or 10 minutes. We will then have a brief discussion among ourselves, and then open it up for conversation with all of you. Immediately to my left is a man who had the foresight to study the NSA long before anybody else, most people, had even heard of the agency. And I think it's safe to say that Jim Bamford is the world's leading expert on the history of this institution that has been at the focus of these revelations. And so he has written numerous books as well as articles, and these days is sought out by journalists, by governments, by various people who are trying to understand how we got to where we are. Further down the table is Rachel Levinson-Waldman, who focuses on this issue as counsel for the Brennan Center, in particular its Liberty and National Security Program. Rachel previously had worked for the American Association of University Professors, focusing on issues of academic freedom and the First Amendment. And before that was actually a trial attorney on housing and civil enforcement for the Justice Department Civil Rights Division. Rachel's going to talk in particular on the issue of, what exactly does the NSA do with the information that we collect, and also, what are the ways that it claims to minimize the intrusion on our privacy, and how actually does that play out in practice? And finally, at the other end of the table is Jameel Jaffer, who is the Deputy Legal Director for the ACLU, who has, again, written and spoken extensively on these issues. He's probably known foremost for some of the FOIA work, the Freedom of Information Act work that he did, which led to very important revelations about the Bush administration's counterterrorism excesses, the so-called torture memos justifying the abusive interrogation practices, the observations of the FBI, details about what went on in Guantanamo, and the like. And so Jameel has been leading the ACLU's efforts on these issues of electronic surveillance. So Jim, why don't I ask you to begin and just explain from a historical perspective, how did we get here?
Sure, thanks, Ken. Great being here at the New School. Appreciate all your coming here. It's a really important issue that I've been following, as Ken said, for a very long time. Actually, to a lot of people's surprise, the NSA actually began not too far from here. I think it was 141 East 37th to 38th Street. Back in the 1920, the NSA predecessor was called the Black Chamber back then. It started out in a 4-story townhouse right on the east side in Manhattan. And the chief of the Black Chamber lived on the top floor, and the first floor was a cover organization, supposed to be a commercial code company to hide the real purpose of the organization, and the 2 floors in between was where the work was done. So it's gone from that townhouse to basically an entire city now. It occupies almost an entire city halfway between Washington and Baltimore. It's almost 100 buildings, 32 miles of road, has its own police force, own fire department, own post office. It's virtually a secret city. So over the years, it's grown enormously, but in almost total secrecy. The NSA, unlike every other agency in the U.S. government, most every other agency in government goes through a normal bureaucratic process. The bill is proposed, there's hearings in Congress, it's voted on, becomes law, an agency becomes an agency. NSA, however, unlike the CIA or any other agency, was formed by a top secret memorandum in 1952, signed by President Truman. And even its existence was supposed to be secret from Congress. And it lasted in almost absolute secrecy for almost a decade until basically there were a couple of spy scandals, and the word came out that there was this agency. So it's very different from most other agencies. It's also had a very bad record in terms of violating the law. As a matter of fact, if it was a person, it would probably be jailed for a very long time under the 3 strikes rule, since it's violated the law at least 3 times in terms of eavesdropping domestically. So it's the recidivism rate is fairly bad for NSA. Just to start back from the beginning, in the 1920s, after World War I, there was during World War I, there was censorship, but after World War I, everything went back to laws of privacy and so forth. So the Black Chamber back then needed to get access to the telegrams, and it went to Western Union. And they convinced Western Union and the other companies to hand over all the telegrams to the Black Chamber. And that went on for the length of the Black Chamber. And then after World War II, it was the same thing. The NSA began secretly making agreements with the telegraph companies. And what they did was they formed a little company here in Manhattan. It was it was made to look like a television tape processing company. And what would happen is the NSA, every night after midnight, they'd have people going from this phony company in Manhattan to the back door of Western Union and the other telegraph companies, and they'd knock on the door, and the companies would hand over all the telegrams for all the telegrams that came into the country, went out of the country, or went through the country. Then they would take them back to this little phony company where they had these machines that would duplicate all those big computer tapes of telegrams, and they take the originals back to the companies before the day shift came, before the morning shift, because it was only the night shift that was allowed to know that the NSA was accessing these telegrams. And they'd send the duplicates down to NSA headquarters at Fort Meade every morning. And then once they got down there, NSA had this very secret computer. It was called Harvest. It was the largest, most powerful and fastest computer in the world at the time. And that's exactly what it would do. It would harvest all those telegrams for whatever name or word or phrase or whatever it is they were looking for. If it was James Bamford, then any telegram mentioning me that day would be kicked out and kept for analysis. Again, none of this was ever done legally. Legally, if you wanted to get one person's telegram, you'd have to have probable cause, get a warrant from a judge, and so forth. And this was every telegram, every day, every year, for 30 years. It was only discovered in 1975 by the Church Committee, the committee set up in Congress and the Senate to examine the abuses of the intelligence community. And actually, both the Democrats and the Republicans were outraged by the abuses, that NSA was doing this for 30 years without any kind of legal authorization. So they set up a separate court they called the Foreign Intelligence Surveillance Court, a secret court where even its location was supposed to be secret. And then they set up, in case the FISA court turned the government down, which it didn't do very often, hardly ever turn the government down, but just in case, they set up another court, a FISA court of review, an appeals court for the FISA court. And they became sort of the Maytag repairmen of the federal judiciary. I think they handled one case in 30 years, or maybe two cases. So the FISA court very rarely turned the government down, but even still, when the Bush administration came in after 9/11, they decided to bypass the FISA court and began eavesdropping illegally. Again, now this is the third time. After World War I, they did it. After World War II, they did it for 30 years and under Operation Shamrock, and now they're doing it again. And the telegraph companies, in this case, the telephone companies, are all cooperating. So the NSA began eavesdropping on all this communications for about 2.5 years until the New York Times broke the story. And then Congress pretty much said, we'll keep the system the way it is. We'll let you keep doing this, and we'll just change the law. We won't stop it. We'll just make the law accommodate what you're doing. And they created this thing called the Foreign Intelligence Amendments Act, the FISA Amendments Act, which is some of the information that's coming out now from the Snowden documents, showing exactly how they were collecting everybody's metadata, under the theory that everybody in the United States is a suspect of something. If you're 5 years old and can answer a telephone, you're a suspect of some sort. And they have the right under the Patriot Act, because the Patriot Act says if you're a suspect of some crime, they can get your business records. So most people would think that, if you're suspected of embezzlement or terrorism, they can go to the bank and get your banking records. And the NSA extended that to say that everybody in the U.S. is a suspect. Everybody in the U.S., we can collect their telephone metadata, which means the same information you get on your telephone bill every month, and to keep it for 5 years without ever asking anybody's permission. So that's sort of a little brief history of where we are now and how we got to where we are. It's very interesting now because when I first started writing about this, Very few people had really even heard of NSA. It was called No Such Agency back then. The initials, they said it stood for Never Say Anything. And the joke I hear now up there at NSA is now NSA stands for Not Secret Anymore. And just one final little anecdote there. When I first started writing in 1982 about this, my first book, The Puzzle Palace, came out in '82. I was doing a book tour with one of the people at one point was Senator Bill Bradley. And he was going to be talking about the economy on a TV show, and I was going to talk about my book. So we're in the same car and going to the studio, and he said, "What's your book about?" And I said, "It's about NSA, the National Security Agency." And he said, "What's that?" I was explaining to the senior senator what the most powerful intelligence agency is in the U.S. So that was one of the reasons I wanted to write it, and one of the reasons I wanted to focus so much on NSA, because it's such a powerful organization, but yet at the same time, such a little-known organization. So that's just a little brief summary, and I'll be happy to take questions later on. Thanks very much.
Okay.
Thank you.
I thought we'd now move on to Jameel to talk a little bit about the law that, in theory, is governing this.
Sure. So let me first say, thanks for the invitation. It's great to be talking about this here. Before I talk about the law, maybe it's worthwhile just to review some of the things that we've learned over the last few months, so that we're all starting from the same place. I think anybody who's been reading the newspapers would probably agree that some of the disclosures based on the Snowden documents are actually quite dramatic. One of the programs, the first program that was disclosed by The Guardian and The Washington Post, is one of the programs that Jim was referring to, this call records program, under which the NSA is collecting information about every single phone call made on a U.S. phone network. That means every time you pick up the phone, in a certain sense, there is a notation in the database, in the NSA's database, of who you called, how long you spoke to them for, and when you called them. Every single time you pick up the phone. It doesn't matter whether you are suspected of being a terrorist or suspected of doing anything wrong. Every single person is tracked in this way, and they've been doing it for 7 years, and they intend apparently to do it indefinitely. Sometimes when that program is described, the government defends the program by saying it's just metadata. It's just information about information. It's not content. It's not the content of your phone calls, or the content of your emails. And I think that it's maybe worth just emphasizing how sensitive that information is, how sensitive this so-called metadata is. If you think about some of the phone calls you might have made over the course of your life, a phone call maybe to a particular kind of doctor, to a cancer clinic, or to Planned Parenthood, or to the ACLU. Maybe you called a lawyer at some point, a criminal defense lawyer. Maybe you called a substance abuse clinic. Any one of those phone calls tells the government a lot about you. And if the government aggregates that kind of information over time, it tells the government even more about you. It tells the government your political beliefs, your religious views. It tells the government all about the rise and fall of your intimate relationships. And if the government aggregates that kind of information over hundreds or thousands or millions of people, or hundreds of millions of people, it tells the government even more, which is why the government wants the information. But people should understand how sensitive the information is. So that was one of the programs. The second program I think we've learned a lot about. Again, this is something that Jim referred to. There was a law passed in 2008 called the FISA Amendments Act, which ratified the Bush administration's warrantless wiretapping program and further expanded the NSA's surveillance authority. We knew something about the NSA's surveillance authority because that law was on the books. It was a public law. But we didn't know how the law was being used. And it turned out that that was a very important thing, that we didn't know how the law was being used, because it allowed the government to keep cases out of court. Every time somebody sued over the law, the government would say, you can't sue over this law because you can't show that your own communications were monitored under it. Because all you had was the law. All you had was the public law. You didn't know how the government was actually implementing it. Now we know how the government is implementing the law. It's engaged in large-scale, suspicionless surveillance of Americans' international phone calls and emails. So when you make an international phone call or you send an email to somebody overseas, that email can get swept up into one of the government's dragnets, and the government can collect the content of the email or the content of the phone call and store it in a government database if they believe that it contains foreign intelligence information, which is a phrase that is very broadly defined to include essentially any conversation about foreign affairs. If the government concludes that the conversation relates to foreign intelligence information, it can keep that conversation or that email indefinitely. So that's a second program. And then a third one is one that was disclosed just yesterday by the Washington Post about the dragnet collection of location information. I think 5 billion records a day collected by the NSA about people's locations. And again, it's like metadata. You know, it seems maybe on its surface, maybe not that sensitive. But when you aggregate this kind of information over time, you can draw all kinds of accurate conclusions about people's associations, their beliefs, which again is why the government wants the information, but also why the information ought to be protected in some way before the government has access to it. So those are the programs. There are a lot of questions that I think one could ask about those programs. I think the questions fall into 3 or 4 categories. The first is just about the scope of the programs. Does the government need to be collecting all of this information? And you could approach that question in 2 different ways. You could approach it from a kind of policy perspective. Is it a good idea for the government to collect all of this information? Or you could ask, is it lawful for the government to collect all of this information? And I think many people, including those of us at the ACLU, think that if the Fourth Amendment means anything at all, it means that the government should have to cross some evidentiary threshold. It should have to prove some suspicion, prove that you've done something wrong or that there's reason to believe you've done something wrong before it gains access to this kind of sensitive information about you. If the Fourth Amendment doesn't mean that, it's not clear what's left of the Fourth Amendment. So that's, one question is about the scope. A second set of questions relates to the oversight over these programs. As Jim mentioned, the court that oversees all of this is a court that meets in secret, allows only the government to appear before it, rarely publishes its decisions. It's not the kind of court that American law students learn about in law school. In fact, I had never heard of the FISA court until I graduated from law school and started working on all of this stuff. So you have to ask, is that sufficient oversight? Or is the Senate Intelligence Committee or the House Intelligence Committee, are they exercising sufficient oversight when all of these programs have gone on without the Senate Intelligence Committee or the House Intelligence Committee protesting at any point? And to the contrary, once the programs were disclosed, those committees, with some exceptions, important exceptions in their membership, those committees defended the programs. And then finally, I would say that the last set of questions has to do with transparency. Do we know enough about what the NSA is doing? We don't know until Edward Snowden released all this information. We had no idea what the FISA court's legal interpretation of these laws on the books was. We knew what the law on the books said. We knew we could read Section 215 of the Patriot Act and draw some conclusions. But we had no idea that the FISA court had interpreted all of this stuff so broadly. And even now, we have no idea the scale of the government's, I shouldn't say no idea, but we don't have a complete sense of the scale of the NSA's activities. We don't know how many times they're relying on these provisions. We don't know, when they do rely on these provisions, how many people's privacy is implicated. So all of those questions are still unanswered. So, that's the way I would approach. I would suggest you could start thinking about those questions. Now, Ken asked me to talk about the law, and I've already used up all my time. So maybe in our exchange, I can get back to the law.
Rachel, do you want to? All right, Rachel, why don't you pick up with, once they get all this stuff, what do they do with it?
Sure. Yeah, and I think this is a really important piece, and I'm glad to be here. And I think both the history that Jim presented and sort of the framing that Jameel presented are really important. I think one of the other pieces that certainly I think is talked about sort of within the, community that's interested in surveillance and privacy issues, but probably isn't as obvious to the public or isn't focused on as much is what happens once this information is collected. So as Jameel said, we have been learning more and more about this phone metadata that's collected, about email metadata that was collected, information about when and to whom emails were sent. That program was shut down in 2011, but it went on for 7 years. And it was shut down finally, basically under pressure from several senators. We found out about a variety of other programs involving what are called buddy lists and address lists, social network information. Much of this is focused overseas, but it's gathering up really significant amounts of Americans' information along the way. And so then there are a couple of kind of additional questions that poses. So I think one is, how long is that information being kept? And how is it handled once it's brought in? So I just want to address a little bit about those two, and then I'm sure we'll talk about them more as part of the discussion. In terms of sort of the specifics of how long this information is kept, there are some areas where we know the answer to those questions and some where we don't. So for instance, now we know with the phone metadata that's being gathered, the NSA keeps that information for 5 years, basically so that it can go back and try to sort of see what associations are hidden in that data. With the email metadata that was being collected until 2011, it was basically about the same. It was 4.5 years and then 5 years, but it was still this notion of keeping information for a long time, very explicitly on the basis, on the justification, not that the information was, that every piece of information being gathered was important and relevant at the moment that it was gathered, but that basically what the NSA needed was this massive database of information because some of it might be useful in the future and because it could only do its analysis with this huge database. And there are significant questions about both of those, both whether we think it's legitimate for a domestic intelligence agency, and in fact, it's an intelligence agency that is supposed to be focused solely overseas. It's not a domestic agency like the FBI is. So whether it's reasonable for an intelligence agency to be gathering lots and lots of information because it might be useful in the future. And then second, it says, well, this is the only way that we can run the analysis that we have to do. But one of the things that we've learned is this email metadata program was shut down. The NSA says it was because of operational considerations, but Senator Wyden and others have basically said we kept asking them to tell us what successes they were having with it. And basically the answer was not enough and maybe none, certainly not enough to justify it. And with sort of rounds of testimony in front of Congress, we've learned the same thing about the phone metadata program, that there are very few kind of counterterrorism successes that it's really significantly contributed to. There are other kinds of information. Some are kept for 2 years, some are kept for 5 to 15 years. Information about Americans' communications that's kind of swept in accidentally, basically, can be kept for up to 6 years to then determine if it contains foreign intelligence information or evidence of a crime, and then it can be kept for longer. So you have really this kind of landscape of lots of different periods. And for some of them, we still don't know how long the information is kept. And then the other piece that I'd like to touch on is sort of how this information is handled. So one of the things that the NSA has said repeatedly is, yes, we're collecting a lot of information, and for some of it, we're keeping it for a long time. But there are these incredible controls in place. So you have the Foreign Intelligence Surveillance Court that Jim and Jameel talked about. There are all of these internal procedures. There's oversight from the executive branch. There's oversight from Congress. And I think one of the stunning things has been to learn over and over and over again, and again, just recently, this has been becoming public, to what extent those oversight mechanisms have failed. And failed very explicitly. Part of it with respect to Congress is that there's so little information that's shared. An event that Jameel and I were both at a few months ago, there's a Representative Mosh from Michigan, who is there talking about what he called sort of the game of 20 questions that members of Congress have to play with the NSA to find out what's going on. And he said, literally, you have to know the question to ask. So the examples he gave were, is the U.S. developing a robotic talking bear? Is the U.S. developing a moon base? And so And that without knowing those specific questions, there was no real information that was coming in. And maybe more troublingly, what we've seen both from testimony to Congress and from decisions that are either being leaked or that are being declassified from the Foreign Intelligence Surveillance Court is that time after time, year after year after year, the NSA was withholding information, was misrepresenting information to the court, didn't know how its own programs worked. There were failures of oversight and kind of so-called minimization for years because nobody at the NSA understood how its own phone program worked. And so I think you have this combination of information being taken in because it might be useful in the future, kept in some circumstances for pretty significant amounts of time, and then, at least in the past, and there's no reason to think this isn't still happening, continued serious failures of oversight and control over that information.
Okay, thanks very much. I'm just going to have a bit of a conversation with the panelists, and then we'll open it up. Jim, I wanted to start with you. You talked a bit about the NSA and its predecessors just ignoring the law. Are there cases historically in which the NSA has misused the information that it has collected so that it's not used for what you might call legitimate security reasons, but for other purposes?
Sure. During the Nixon period, for example, Nixon turned the NSA loose domestically, basically to go after anti-war protesters. And interestingly, and you could see this in the Nixon tapes that were released, where he ordered the NSA to begin eavesdropping domestically, both what had already been eavesdropping on all the telegrams, and now he ordered the NSA to begin eavesdropping on the telephone calls also. And it's interesting because the reaction at NSA, it's actually quoted, the comment that was made by the deputy director at NSA when he was told by the director, he was overjoyed that NSA would now have this authority. And you see this constantly at NSA where they constantly want this authority to move closer and closer to domestic activity. What's interesting was that there was this great civil libertarian who stopped the whole program. His name was J. Edgar Hoover. A week after Nixon ordered this program, it was called the Houston Plan, Hoover went to Nixon and basically threatened him that there may be a leak about all this if this keeps on going on. And it was because Hoover's feet were being stepped on. Yeah, it was moving into wiretapping was Hoover's business. It wasn't the NSA's domestic. NSA could do whatever they wanted outside the country, but inside the country is J. Edgar Hoover. So there have been examples of that. When I interviewed a person for my most recent book, The Shadow Factory, who was a intercept operator down in Atlanta, or outside of Augusta, Georgia. It's NSA's largest listening post, 4,000 people down there eavesdropping largely on the Middle East and so forth. She told me that at the time she was ordered to eavesdrop on Americans calling their spouses back in the U.S. And a lot of times they were very intimate phone calls, and she complained about it. And she said it was like reading somebody's diary, but she was ordered to keep, even though she protested, she was ordered to keep listening and keep transcribing and making a record of the whole thing. She eventually complained all the way up the chain of command, both within the NSA and then to the Senate Intelligence Committee, and nobody did anything. And finally she told me about it, and I wrote about it, and after I wrote about it, then there was a congressional investigation into it. But so there's numerous examples. I could go on to a number of others, but those are some examples of how it's abused.
Well, you're alluding to what happens when somebody complains, and Snowden has been criticized by the government for not following the proper procedures when he has a complaint. There's an inspector general within an NSA. There are the Senate and House Intelligence Committees. But Snowden was obviously aware of a certain history of attempts to use those mechanisms. And could you maybe go into a few examples of others who have tried that route?
Sure, yeah. One of the cases some of you may have heard of, his name was Thomas Drake. He was a senior NSA employee, senior being a colonel or higher at NSA, and a civilian, but the equivalent of a colonel or higher. And he was aware of a very bad program that was where a lot of money was being wasted on a program called Trailblazer. And he went all through the internal workings, Inspector General, everywhere else, and there was nothing ever done about the program, and he thought it was an enormous waste of money. So he wanted to alert the public to it. And he told the Baltimore Sun about it. And they did a few stories. And then they arrested Tom Drake. And they charged him with 5 counts of espionage. And he ran out of money. They had the case go on for about 4 years. He hired an attorney until he went bankrupt. And then he had to get a public defender. And then the public defender hired me as a consultant on the case. And my job was basically to take a look, in essence, at what it was that they were charging him with, 5 counts of espionage, 35 years in prison, and just see if those are really secrets. And what I was able to do was I was able to come up with a stack of documents in about 3 months or so, and we were able to show that all the information they were charging him with was not only in the public domain, but had been placed in the public domain by the government itself, largely a lot of it by the NSA. So at the end of the case, the judge ended up, at the end of the case, when we presented that information to the judge and the prosecutor dropped the entire case against him and had him just agree to plead guilty to a misdemeanor without any jail time and no fine. In other words, less than a parking ticket. So he went from potentially 35 years in prison to less than a parking ticket because the NSA doesn't know what's secret and what isn't, and what's out in the public domain and what isn't. So that's one of the examples of the government coming after whistleblowers when the whistleblowers weren't really blowing any secrets. And was there another question on that?
Well, it's really, is there ever a whistleblower that we're aware of who has been taken seriously by the system?
Well, that's the other problem, was that when you're talking about Snowden, I wrote an article for Wired, a cover story last year on the NSA's large data center they're building in Utah, 1 million square feet, largest data center in history. It's where they're going to store all that metadata and everything else they pull in. $2 billion building and so forth. I interviewed a number of former NSA officials, including Bill Benny, who had worked there almost 40 years, and a number of other people. And he would have been a general if he was in the military. He was a civilian. And he was the one who automated the NSA system all over the world. So he cooperated with me, and he even used his name in my article as well as other people. Then NSA came out a week or two later and said, oh, well, this is exaggerating. He doesn't know what he's talking about, that kind of thing. And those are the kind of things that Snowden saw and realized that if he wanted to be a whistleblower, it's not going to do much good to come out and say the NSA is doing this and the NSA is doing that, because they're just going to say that's nonsense, he's making it up, and so forth. And then it's the NSA against you. So that's one of the reasons why I think he, and I actually he's indicated that he's that he decided to go the route he did, which was actually exfiltrate all these documents so the government can't say, well, this really isn't true. So these are examples of how whistleblowers have decided to strike back at the NSA because they found no other way to get the information out.
All right, thanks. Jameel, you talked about both metadata and the Fourth Amendment, but I wanted you to give you an opportunity to explicate that a
answer
little
your
bit.
earlier
Because,
question?
yeah, because I mean, in other words, I think most people are not aware of why our metadata is not protected, and what is the theory that the Supreme Court put forward that has led us in that direction.
Well, so there's a case from 30 years ago called Smith versus Maryland, which involves something called a pen register, which is a device that the government can install on a phone line to track who is calling and who's being called. Essentially the numbers to and from. And that case involved it was a criminal investigation. The government installed a pen register on somebody's phone line for 2 days. And at the end of which there was a criminal trial, and the defendant moved to suppress the evidence on the grounds that the seizure of this metadata had been unconstitutional. And the Supreme Court held that the defendant had no reasonable expectation of privacy in that pen register obtained metadata. Now, again, it was a single person suspected of a crime, and the pen register was in place for 2 days. The government is now relying on that case as the justification for a program that involves the collection of everybody's metadata, and has a program that's been in place for 7 years already and counting. And so, there is this debate about whether that 30-year-old case that the government is relying on does in fact stand for the proposition that the government says it stands for, which is that metadata is unprotected. We have a case pending now in the Southern District of New York. It's a challenge to the constitutionality of this call tracking program. And the government is arguing, among other things, that the Fourth Amendment doesn't protect Americans against the collection, even on this grand scale, of their metadata. Now, and this is to answer the question that Ken asked at the very beginning. One thing that I think a lot of people don't understand is that all of these surveillance issues that have dominated the front pages, not just for the last few months, but since 9/11, these surveillance issues have been on the front pages over and over again. All of those issues get debated in the public sphere to some extent, to the extent we have information. They don't actually get adjudicated in the courts, and the reason they haven't been adjudicated in the courts is that every time somebody walks into court, the government makes the argument that I referenced earlier, this standing argument. You can't sue because you can't show that your communications were monitored. And if the plaintiff says, well, give me more information then about how the NSA is implementing its authorities, the NSA's response is, well, that's a state secret, and we can't litigate this case without the disclosure of state secrets, and therefore the case has to be dismissed. And that sounds, absurd to a lot of people who don't practice in this area, but the NSA has been successful in doing that over and over again, not just since 9/11, but going all the way back to the 1970s, late 1970s. The NSA has managed to insulate virtually all of its surveillance from judicial review and to place all of that surveillance beyond the reach of the Constitution. So the fact that we are now able to argue about whether metadata is or isn't protected by the Constitution is actually an amazing thing to anyone who practices in this area, because for 30 years we've been stuck at the doorstep. We have been knocking on the door to the law, right? And finally we're inside and we can have this debate. Whether we'll win it, I don't know, but it's nice to be having it, and we have Edward Snowden to thank for that.
Well, Jameel, let me, you allude to the 1979 case, Smith versus Maryland, where the court said there's no reasonable expectation of privacy in your metadata, in that case, in the numbers you dial. The rationale they gave was an interesting one. It was that you shared those numbers with the phone company, and once you share them, therefore, they're not private. Now, it could have easily come down differently. It could have said, well, the phone company has a duty to respect your privacy. They have a fiduciary duty of some sort, and therefore you're not really sharing them with a third party any more than, when you speak to your lawyer, you're not giving up your privacy because your lawyer has a duty to respect that confidentiality. It didn't go that route. On the other hand, it didn't go the other extreme either by saying, well, you're also sharing your voice data with the phone company. So you don't have an expectation of privacy in the content of your communication. It didn't say that. And it looks, you could say, well, there's a distinction between the number versus the voice, but when you get to email, there's no distinction. It's the exact same data
That's
stream.
right. That's right.
The address, the addressee of your email, and the whatever you type in. So, I don't know if there's an answer to this, but what was the court thinking? How did it come up with this rationale?
Well, I don't know the answer to that. That case, Smith versus Maryland, is often taken to stand for the proposition that information you share with a third party, information you entrust to a third party, by virtue of your having entrusted it to a third party, you lose your constitutionally protected privacy interest in it. That's the principle that people take that case to stand for. It can't actually stand for that principle because, as Ken notes, there are a million other contexts in which you share information with third parties, and yet the courts don't say when you talk to your lawyer, or you talk to your doctor, or you share information, you share the content of your phone call with the phone company. Nobody says, well, you've lost your constitutionally protected privacy interest. So the third-party records doctrine, which people find in Smith versus Maryland, I don't think it actually means what people sometimes say that it means. But so this is one of the arguments that the government has made to insulate this particular program from challenge. But the other one that the government is relying on here, I think this is interesting, and it has application to all the other programs as well. The government is arguing that there is no Fourth Amendment event, that the Constitution doesn't actually care about collection of information. The Constitution only cares when the government looks at the information. And so they're trying to separate the front end from the back end, right? The government is saying, we can collect everything. The Constitution doesn't care about that. If we look at it, then we need to have a justification sufficient to satisfy a judge and satisfy the Fourth Amendment. And
where did that come from? Did they just make it up?
Well, they did just make it up. It's a good question when they made it up, because if you look at, this is a bit weedy, but if you look at the 30-year-old signals intelligence directives that the government has been relying on for 30 years, they distinguish between acquisition on the one hand and collection on the other hand. And there is that distinction, but it's never been a distinction that has had to be defended in an open court. This is the first time that we've been in a position to say this distinction makes no sense. And if you accept it, it's not just metadata that the government will be able to collect. It's the content of every phone call. It's the content of every email. All of this stuff is your location. All of this stuff could be stored in government databases indefinitely without the Constitution caring about it until the government at some point in the future decides, here is a person we think is suspicious, and we want to go back and see everything that they've done over their lifetime. Where were they 30 years ago? What emails did they send when they were in high school? They want to create a kind of a situation in which nothing can be forgotten, at least by the government. And to me, it's actually quite a shocking thing that the government is arguing that the Constitution is indifferent to that kind of thing.
One other aspect of that is the fact that, look at the Snowden case here, where Snowden is a contractor. He was in his 20s, didn't even have a high school diploma. He's working for a contractor in an outstation in Hawaii, yet he had access to was apparently between 50 and 200,000 pages of documents. So the government collecting all this information doesn't mean somebody can't exfiltrate it and sell it to some company or some terrorist group or some country or some the mafia or whatever, some organized crime group. So by the collection of all that information and then having such weak protections on it, it gives everybody there's a threat not only that the government's going to look at it, but the threat that somebody else can look at it if it gets exfiltrated. And the thing with the Snowden case is that the NSA didn't even know. Snowden had been doing this for close to a year, I think it was. And the government had no idea he was taking all this information until he actually went to Hong Kong and announced it himself. So collecting all this data, the content as well as the metadata, you're the government is putting everybody's privacy at risk with having such poor security at the back end.
Yeah. No, I mean, I've written about, this claim that there's no privacy interest in the collection of our information, only when the government looks at it. And, imagine the government putting a video camera in your bedroom and saying, we're going to collect all this information, but don't worry, your privacy isn't invaded until we look at it. You'd feel comfortable with that, right? But that's the state of the law right now.
And that was one of the documents that actually came out just last week, was a document from Snowden that said that, it's very interesting that it was a document from NSA, and it said that we're monitoring people's access to porn sites. Maybe we could use this as a vehicle for attacking the reputation of a number of the people we consider radical. And that strikes way back at what the FBI did during the Hoover years with Martin Luther King. And this was a document just released. It was actually in Huffington Post last week, released by Edward Snowden. I was actually in Rio with Snowden at the time they did that. I read the entire document, and it was really shocking.
With Greenwald.
I mean, with Greenwald, sorry, yeah. With, no, not with Snowden, but with Glenn Greenwald, and I read the entire document. I was really shocked because I wrote about this stuff back in the 60s, and here we are tracking people's porn sites and using it to discredit them.
Yeah. Jameel, one last question for you, and then I'm going to go on to Rachel. But the Jones case from a year ago, and Justice Sotomayor, it's an extraordinary case, and could you just kind of run through what that might portend for the future?
Sure, right. So this one is, again, a criminal case involving somebody who was tracked with a GPS device by the police for several weeks. And the question was whether the government's collection of that kind of location information over about a 4-week period infringed a reasonable expectation of privacy under the Fourth Amendment. In other words, whether it triggered the Fourth Amendment. And the government pointed to, again, a 30-year-old case or 20-year-old case in which the court had upheld the police's tailing somebody with a, they put a police car on the tail of somebody else, and the government said, look, you guys said it was okay for us to do that, and that the Fourth Amendment was indifferent to that kind of surveillance. And the government pointed to another case involving a beeper from a long time ago, and said, you didn't care when we did that kind of surveillance. Why should this kind of surveillance violate the Fourth Amendment? And a lot of people thought that the government would win that case. But all 9 justices of the Supreme Court agreed that the long-term, this particular kind of collection of location information infringed a reasonable expectation of privacy. Now, they reached that conclusion for different reasons. Some of them thought that the problem was trespass, so the government had installed the device on a car, and there was a physical trespass, and that infringed a reasonable expectation of privacy. But 5 justices went further and said that we would hold that, or we would conclude, there's some debate about what the actual holding of the case is, but we would conclude that long-term aggregation, collection and aggregation of location information violates the Fourth Amendment. And Justice Sotomayor has a very eloquent opinion explaining how sensitive this information is and how it would change the relationship between citizens and their government if the government could have ready access to this kind of information about anyone. It would give the government, again, just like with call data, information about your religious views and your political views and your intimate relationships. All of that would be at the government's fingertips without the government having to justify to any court that they were entitled to the information.
Yeah. What I thought was fascinating about that case is that you had the 4 liberals plus Alito, who were basically willing to conclude that this collection of your metadata did implicate your privacy. And then Sotomayor sort of did the Obama administration a favor by not voting on that basis, but voting on the narrower trespass basis. And it's almost as if she was saying, okay, we're going to give you one more chance to clean up your act. But if you don't, you've got 5 votes against you, and you're going to lose.
Right.
And I think the big test now is, will this reform panel heed that warning, or is it going to fall back on the court to fix things up? Rachel, I wanted to ask you, you alluded to the lack of success here, the lack of real, kind of in fact rationale for this mass sweeping up. And could you just elaborate on that a little bit, and maybe also just explain, what we're not challenging? In other words, the targeted versus mass surveillance.
Sure. Yep. So there's a couple of issues there, right? So as Ken says, there are a variety of different kinds of surveillance that the NSA engages in, and some of it is targeted surveillance. So a specific person is identified. That could include a U.S. person. There's a very specific kind of order the NSA would get it, similar to an order in a criminal context. And largely, you can sort of quibble on the margins, but largely I think there's not nearly as much concern with the notion that somebody has been identified, for instance, as the agent of a foreign power, would be, and that their communications would be monitored or surveilled to gather information about foreign intelligence. The context in which a lot of the recent revelations have come out and recent concerns have been raised is a couple of different things. It's partly, and some, I guess I'll broadly distinguish between surveillance that is very intentionally focused domestically, and collection that is focused internationally, but is gathering in a large amount of information about Americans. So the collection that's happening domestically, there are a couple of interesting pieces about this. One, and this is a little bit of a side note, but we can also get into more of this, is the interplay between the NSA and the FBI. So a lot of what's been coming out in public is the kind of information that the NSA is gathering domestically. And so this is the phone metadata that Jameel was talking about, and then this email metadata collection program that was going on for 7 years that was just shut down a couple of years ago. In order to get this information, because of the particular way they were getting it, especially the phone metadata information, the NSA basically had to partner with the FBI. The FBI is the one that would go to the FISA court, would sort of make the case, but then all of this information gets funneled to the NSA. And there are kind of interesting, quirky legal questions that raises as well, because there are basically controls, there are kinds of minimization procedures that the FBI would have to impose if it was receiving that information. It's not clear that the NSA has to play by the same rules. So you have this interplay between the two agencies, and at times it's a very uncomfortable interplay. There have been times when the FBI, or not the FBI, but the DOJ itself has gone to this court and said, look, we as the lawyers have discovered there is stuff the NSA is doing that they're not supposed to, and we've come to you to tell you that. So when you're talking about that kind of collection, so what we've learned, and I'll start first with the phone metadata collection, because that is the very first, literally I think on June 6th, the first document that Edward Snowden released that kind of started this whole avalanche of information was about this phone metadata collection program. And so not surprisingly, officials with the NSA started getting called before Congress to say, what is going on? Why haven't, there were some people within Congress that knew about it, but why wasn't it more broadly understood? What's happening with this information? And one of the most interesting parts is that you sort of see this gradual kind of falling apart of the case that the NSA tries to make to Congress. So first they say, I believe, that the phone metadata program contributed to thwarting 54 terrorist plots. And then under question, they say, well, only 13 of those, I think, had sort of a nexus to the United States. Then they say, well, and only 1 or 2 of those was this program really critical to stopping it? Was this really an important piece of information? And then it turns out that at least one of those was a case of somebody who had given $8,000 to Al-Shabaab, which is a recognized terrorist organization. But the notion of collecting every single American's phone call, information about their phone calls, and collecting it for 5 years so you can thwart an $8,000 donation certainly seems disproportionate, to say the least.
Well, not to mention, aren't they monitoring Al-Shabaab's phones?
Right. Presumably there could have been other ways to find, and I mean, that's a financial transaction, right? So there are actually quite strict controls on and oversight over financial transactions, which which I think a lot of people wouldn't have as much issue with, right? So banks have the obligation to report certain kinds of transactions. So, right, you would think also that there would be a variety of other ways that this information would come out than tracking phone metadata. With the email metadata program, again, there hasn't been as much recently in terms of testimony to Congress since the program was shut down a couple of years ago. But as I mentioned, what's come out, especially from senators, is saying, look, what the NSA is saying is, oh, we decided to stop this program. And what was going on behind the scenes was that the agency was being repeatedly pressed by a couple of senators, especially Wyden and Udall, who are on the Senate Intelligence Committee, and so actually had access to a lot of the classified information underlying the program, and that sort of spoke to what successes the NSA was having with this program. And basically they kept pressing the NSA to show them what was this program actually accomplishing that justified both the intrusion into privacy and just the resources. Any of these programs, and I'm sure Jim can speak to this more, takes analysts, takes money, takes computing power, takes analytical power, and there's got to be some pretty significant payback for that. And then the other part that Ken was asking about was sort of this more, I hesitate to call it more broad scale, but a different kind of broad scale collection. So as I mentioned, the NSA by mandate is supposed to focus overseas. It's supposed to focus on foreign collection, foreign intelligence. I think Jameel had alluded to, and Jim had alluded to changes that were made to the Foreign Intelligence Surveillance Act in 2007, 2008, basically to ratify warrantless wiretapping. And one of the things that those changes did was to allow these very broad collection orders that the NSA and the Attorney General kind of get together and say, this is the kind of collection that we want to do. That order would be approved kind of as long as it sort of checked certain boxes. It would go on for a year. They would show up a year later and said, yes, we'd like to get this reapproved. So that surveillance, that collection is technically focused overseas. The NSA can't intentionally collect the actual communications of an American through that program. But unlike the metadata programs, what those orders are for is actually to collect communications. So it could be entirely foreign communications. It could be communications between someone outside the U.S. and someone within the U.S. But I would say it is a feature and not a bug of those orders and of that collection that communications to, from, about Americans are collected as well. And I think that we don't know, I think information has been held much more closely about exactly what successes have come out of that program. And even some of the senators, sort of what I would call opposition senators on the intelligence program, haven't been as vocal about shutting those programs down. By the same token, we learn more and more about the extent to which those kind of ostensibly foreign-focused programs, whether it's collecting communications under that particular law or collecting these address lists, buddy lists, social network information, this location information that just came out yesterday, which is under a different authority, how much that's collecting Americans' information, and that's just understood to be basically kind of a price of doing business.
Well, as somebody who spends a huge amount of my time talking and emailing to people overseas, I mean, I have a special interest in this. And a lot of the problem is that, under U.S. law, foreigners have no privacy right whatsoever unless they're in the United States. And, this drives the rest of the world crazy given how much communication is channeled through the United States. And I think there are going to be long-term, very negative consequences for that as various governments insist that data not be repatriated to the United States. That's where we're heading, even though a lot of these other countries don't have very good privacy protection schemes either.
Well, one thing on what Rachel was talking about in terms of the success rate and so forth, just to make it clear in terms of successes and failures, the operations that NSA learned about from CNN as opposed to its own multi-billion-dollar organization is the First World Trade Center attack, the attack on the USS Cole, the attack on the USS embassies in East Africa, 9/11, the attempted Times Square bomber, the underwear bomber, and the Boston bombing. So the cost-benefit ratio there is not very high.
And let me actually add one other piece, if I can, which is that other agencies have said, and the NSA is starting to say this as well in certain contexts, that it's getting too much information. So this is really a problem kind of government-wide when you're talking about counterterrorism efforts. So, I mean, speaking of things like the underwear bomber, the official review of this kind of accidentally thwarted attack was that part of the reason that sort of the dots hadn't been connected was because there was too much information in the system, not because enough hadn't been collected. You see the same thing with there's an official White House review of the shootings at Fort Hood. One of the sort of issues that comes up there as well is that there was too much information. And the NSA has started saying the same thing in some contexts. So with respect to the location information, these revelations that just came out yesterday, they're getting so many billions of records that they're having trouble storing it and analyzing it. The same with the information that came out a month or two ago about these address lists that are being gathered, which could include some email inbox information. Because of spam, basically, their systems were getting overloaded. They were shut down. And this is an agency that has the capacity, in fact, to store billions of records a day. So the fact that there was so much coming in that it was kind of clogging up the system, and you see these same acknowledgments from the Department of Defense, from the CIA, kind of across the board. And so I think there's also sort of a fundamental problem with the notion of if we could just figure out how to use it best, we would want all the information possible. That seems just not to be the case.
One other thing, the NSA also concluded that Saddam had weapons of mass destruction, so you could add that to the ledger.
I'll come to the audience in just a second, so prepare your questions. But Rachel, just one last question. One alternative put forward to the NSA collecting all this information is just to let it stay with the phone companies and stay with the internet companies, many of which store this material for some period of time. And if there are particular queries the government wants done, it can go to a judge, it can justify it, and then it can query that information, which will be there at least for a year or two.
Right.
What's wrong with that approach?
Well, so I think there are a couple of concerns with that approach, and you're right. So right now, phone companies by statute have to keep information about calls that are made for a certain amount of time. So I think the minimum is something like 12 to 18 months. Some companies keep the records for up to several years. And right, one of the proposals has been, okay, let's standardize that and let's increase it. The NSA said it needed this information, needed to keep this information for 5 years. Let's have the phone companies keep it for 5 years instead. And one of the major concerns with that is that if it's held by a private company, it just opens it up to all sorts of other uses. So as part of private litigation, civil litigation, divorce suits, you name it, this kind of trove of information would be out there. And in fact, it wouldn't really be any harder for the NSA to access either, given kind of the free access to this third-party records information. The NSA would still be able to get it, and so would all of these other private parties as well for kind of a whole range of uses.
Okay. Thank you very much, all three of you. Okay, do we have a microphone? Is that how we're doing this? Yeah. Okay. Here we go. Okay. Why don't we take this woman here in the front? But you got to wait for the microphone. It's right there, though. Oh, yeah. If everybody could please just give your name and some kind of identity. Yeah.
I'm Shirley Rauscher, Civil Liberties. I saw a message today, and I'm not absolutely certain from whom. I think it may have been Tom Graham, which I think comes from the Nation group, and said, what if Edward Snowden were to disappear? I thought that was real catchy, so I read it. And he said, didn't mean to really disappear, like get killed or something of that sort, but have the records and everything that he has expunged. 1984 example. Mm-hmm. And some of our countries, as a matter of fact, today don't permit certain information to go through Google. We went through that within recent years. They wanted things changed on Google. So I postulate
I
this
think, yeah,
as.
I think Jim is probably,
a
I mean,
little bit of a question.
yeah, I mean, Glenn is taking
what if?
precautions on this. Jim, you want to talk about that a little bit?
Well, from what I understand, again, I'm an outsider here. I'm not a party to any of this, but from my understanding is that when he left, when Snowden left Hong Kong, or before he left Hong Kong, he turned over the full cache of documents to both Laura Poitras and Glenn Greenwald. So Laura Poitras is now in Germany, and she's free to stay there, and the German government isn't bothering with her activities. As a matter of fact, she's cooperating a great deal with Der Spiegel magazine and other places. And the Germans obviously don't have a lot of love lost for NSA, having eavesdropped on Angela Merkel and so forth. And Glenn Greenwald's in Rio, and he has his own cache. I think it's this identical cache. And again, in Brazil, the NSA was eavesdropping on the president of Brazil. So there's no problem with him using those documents down there. So I don't think either of those governments are going to do anything to destroy those documents. The NSA, however, because I assume that a lot of them are in some sort of cloud architecture of some sort. I keep going like that, but clouds are actually underground or on the ground. But I would assume, again, I'm just assuming, that they have them spread out in a multitude of different cloud structures in different countries. I mean, one of the interesting things about the clouds is that this program that just came out recently that was revealed, this muscular program where NSA, you've got the front door and the back door for these internet companies. Prism is the front door. Well, they'll go there with an order and say, please give me everything you have on James Bamford or on the Brazilian government or whatever. And they do that through an order. Then there's the back door. The back door is that they actually were tapping all the links between these data centers that weren't encrypted. So they could get everything they wanted without really even going through the front door. So I assume that Snowden's documents, and I don't think Snowden has any control over them. I mean, there's these stories about how he has some doomsday architecture up there with somebody comes after him, he'll give a code and the world will come to an end or something like that. I have no idea about that. But I assume that knowing these people, both Laura and Glenn Greenwald, are very security conscious that they have them in a variety of formats and a variety of locations to
Right. Why don't we take
redundancy.
We'll take maybe questions in groups of three, and let's do back here, and then over there. And then, okay.
You mentioned control and oversight of this information, and that there may not be that much. And I was wondering about this, the idea of this information getting into groups of people who may have certain views, and say they decide to use it against certain people within a community. Have you heard stories about that? And is this a possibility that someone extremely progressive could be targeted? Sorry.
Yeah, no, thank you. Why don't you just pass it down? And then go ahead, yes.
Situation that bothers me when it's reported in the news. If a person is accused of terrorism in a civilian court or military tribunal, and the evidence against the guy is classified, seems like the guy cannot hear the evidence against him. How can he be convicted or defend himself? Seems to me the situation is intrinsically unfair.
Hi, I'm Bill McGowan, journalist and author. My question is for Jim Bamford. You mentioned the unplanned and untoward exfiltration of information from the NSA to corporations, other countries, the mob of various stripes. What about the intentional exfiltration of the information, i.e. the sharing of information with allies? I was struck by the Guardian story about the sharing of information that Obama authorized with Israel. And as a journalist who plans on doing a lot of reporting on the ground from the Middle East in the next year or so, hopefully. Should I be concerned? I mean, I've already made some calls to friends of friends of friends of friends kind of thing. And, you know, I don't like the idea of people having my metadata when I'm working in a foreign country. So should I be concerned? What was the rationale for that? And did The Guardian get it right? Because I've heard from a couple of different sources that there's a couple of details that are missing from that.
Right. Maybe, Jameel, you can talk about just the use of this evidence at trial, and Rachel, why don't you talk about just the control of, you know, against misuse of this information? And Jim, you can start off with Bill's question.
Yeah, Bill. Yeah, good question. I read that article also, and it looked like they gave the Israelis access to the raw data of Americans, which again is very scary because the Israelis, who's to say who they're going to give it to? I mean, that was the problem with Pollard. Pollard gave them information from the United States, and then the Israelis ended up giving a lot of that to the Russians. Giving it to the Israelis is giving it to a foreign country without any real control over it. In addition to that, you know, what we haven't really even talked about here is the fact that we're not really talking just about an NSA here. We're talking about a worldwide consortium. It's a thing called the UK-USA agreement that was signed in 1946. And that's where the United States, Canada, Australia, New Zealand, and the UK are all
Five Eyes.
yeah, the Five Eyes. It should be the 10 years. I don't know why they call it the Five Eyes, but you know, they're all collaborative. And I've seen documents that have gone to the British or other organizations, and then the British, in turn, have the addressees on some of their documents, and it's their equivalent of the Internal Revenue Service, their police departments, and so forth. And you're talking about Canada, Australia, New Zealand, UK, and then they can share that information. So you're talking about this information going to a lot of places, and then you have the third parties, who could be European countries, where the French are sharing all their metadata, 70 million communications a month, with the United States, and the Norwegians are sharing 33 million data points a month with the NSA. So you've got all this sharing of people's information all over the world back and forth, and that's really a serious question. How, you know, whether it gets in the hands of a group that nobody wants, you know, a terrorist group or a criminal group or whatever, the odds are it probably will happen at some point.
Rachel, do you want to pick up from there?
Sure. Yeah, and I'll add one piece onto what Jim was saying, which is that as Jim had said, one of the things that came out of the Guardian article, and I think this was from a specific document the Guardian had published. It may be from their reporting, but I think we actually got to see the underlying document. So as you mentioned, the U.S. was sharing what's called raw data with Israel, which is very specifically prohibited by the NSA's own procedures. So one of the things that was leaked back in the summer was these procedures governing how this kind of communication information of foreigners is handled. And one of the things it says is that when information is shared with foreign governments, it's the minimized data. It's not unminimized. It's not sort of these caches of raw data. And then it appeared from the Guardian reporting that, in fact, at least in the case of Israel, and we don't know with what other countries, that restriction wasn't being followed. With respect to the issue of targeting people, targeting groups, targeting individuals, targeting progressive groups, I think what we know from the history, and Jim spoke about some of this, the history of the NSA, and also certainly the history of the FBI. And with the FBI, we're not just talking about kind of church committee era history, we're talking about very recent post 9/11 history, is that absolutely there has been and continues to be targeting of progressive groups. As recently as 2010, there was an Inspector General's report about the FBI targeting groups that were really just engaged in peaceful activities. We haven't found out, frankly, as much about what the NSA is doing. There haven't been the same kind of reports that have come out. We haven't had anything like the Church Committee since the Church Committee. Ken, think Ken or somebody who had raised a question before had talked about, the idea of going to the NSA Inspector General or the NSA Inspector General doing a report. One of the interesting and troubling things about the NSA IG as opposed to the Department of Justice IG and a variety of others, even other inspectors general within the intelligence community, is that it is entirely internal to the agency. The Inspector General is appointed by the director of the NSA. I believe the legal advice that the IG gets is from the General Counsel to the NSA. This is a little bit of a side note, but I think sort of speaks to how much oversight isn't happening in the way that it does happen in some other agencies. One of the documents that was leaked several months ago was a draft NSA Inspector General report. And one of the things that the report talks about is trying to get the underlying justification for, I believe it was the warrantless wiretapping. And that basically there was kind of a representative from the NSA IG's office at a meeting with Cheney, and they said, can we please have a legal memo? And Cheney said no. And that was basically where it ended. And so I think I think to some extent we don't know. It could be that kind of political targeting isn't happening, that there are kind of a variety of other misuses of information, and that's not one of them. Or it may be that there simply hasn't been a forum for that information really to come out.
So we're only.
Files, classified evidence.
Yeah, that's for Jameel's answer. Yeah.
So we're only now starting to learn how this kind of surveillance is, the fruits of this kind of surveillance are being used in criminal cases. The case I referred to earlier, this case in which we challenged the constitutionality of the FISA Amendments Act, that case went all the way up to the Supreme Court. As I mentioned earlier, it got dismissed on the grounds that our plaintiffs, including Human Rights Watch actually, couldn't show that their own communications had been monitored under the law. One of the arguments we made to the Supreme Court in that case was that if you don't take this case now, if you don't consider whether this law is unconstitutional now, you may never get another chance to consider it, because there is no context in which a person will know to a certainty that his or her communications were in fact monitored. And the government's response was, no, that's not true, because we are going to notify criminal defendants. When we use this kind of evidence in criminal trials, we'll notify them. And they'll be able to challenge the constitutionality of the law. And we said, well, 5 years have gone by and you haven't notified anyone, and the government hemmed and hawed. And now recently it's come to light that the government in fact had a policy of concealing the origins of its evidence. When the evidence was derived from the FISA Amendments Act, when it was derived from this kind of warrantless surveillance, rather than provide the notice that the government told the Supreme Court that they were providing, the government was concealing from defendants where the evidence had come from. And it was only after all the Snowden documents came out that the government acknowledged that it had, in fact, had a policy of concealing from defendants the information that it had told the Supreme Court it was providing, which is, a stunning thing. So now the government has changed its policy, and it is in fact providing the notice that it was supposed to be providing all along. And 2 defendants have received notice now that they were wiretapped or that their communications were monitored under the FISA Amendments Act. One is in Oregon, and the other one is in Colorado. And I anticipate that in those cases, the defendants will now have the opportunity to challenge the constitutionality of the law, which is a good thing.
Okay. Come up here, and then in the back, and back over here.
Hi, my name is Emma Roth. This is a follow-up question for Jameel. I read an article this morning from the Times about this new sort of competitive marketplace through which companies like Google and Yahoo tried to sell consumers on how much they protect privacy rights as compared to other private companies. I was hoping you could speak to how much power these companies really have to protect privacy rights, and how an organization like the ACLU would advise them to weigh this responsibility with their obligation to comply with the NSA.
Mm-hmm. Well,
Let's take the 3 questions, and we'll come back.
Oh, sorry. All right.
Okay.
Sorry, here. Okay. Hi, my name's Donna DeSalvo. I'm a curator at the Whitney Museum, actually, And Laura Portress was in our biennial last time, so I had the great pleasure of working and meeting her. I'm curious about, there's a political filmmaker you may know named Emile D'Antonio, and the last film that he made was called Mr. Hoover and I. And it came out in around, I guess, 1991, and it was comprised entirely, he created a portrait of himself based on his FBI file. He was very involved with films about the Weather Underground and Nixon, and he was on Nixon's enemies list. And of course, he talks a lot about Hoover and the way Hoover went after so many figures, as you said earlier, Martin Luther King, Gene Siebert. And I'm just curious, when we speak about the NSA, we speak about it as if it is a person. I mean, it's this anonymous place where Hoover had a face. Do you think that within the government itself, senators, congressmen, who presumably would be subject to the same level of surveillance, that's one question, as the rest of us are they worried that there's a Hoover lurking somewhere in the NSA that may go after them?
Okay, and then I think we had one question back here. Yes.
My name is Connie, a paralegal aspiring attorney for the ACLU. This question might be kind of silly, but I know that the World Intellectual Property Organization, they've obviously gained a lot of ability to create cases on the idea of intellectual property. So, I mean, my texts and my calls are definitely not, have a lot of intellectual. Can you hear me now?
Yeah.
Yeah. So why hasn't this been fought on the basis of intellectual property? Because I mean, it's kind of the case with you. You're obviously exchanging information that you think is an intellectual asset. So why hasn't it been fought in that respect? Yeah.
Okay. So Jameel, why don't you start off with the
Sure. Yeah.
the private companies? Yeah.
I mean, the companies, from I think from our perspective, it's a great development that the companies seem suddenly interested in protecting their customers and subscribers' privacy. And that there is this, I think you characterize it as a competitive marketplace in privacy now. I think that's a great thing, and some of those companies I think deserve real credit for what they've done over the last few months. A few of them, including Google and Microsoft and Yahoo, have gone to the FISA court and asked the FISA court to give them leave to disclose more information about the surveillance that the government has compelled them to facilitate. There's actually a real and notable line between the internet companies on the one hand and the telecoms on the other. The telecoms have done nothing at all to protect their customers' privacy. To the contrary, they are making a profit by selling all of your information. All this metadata is being sold by AT&T and Verizon to various intelligence agencies. So there's a real line there. But I think that you alluded to this, and I think that this is an important point. There's a question how much power these companies actually have to protect privacy against the kind of surveillance that the NSA is engaged in, because the NSA is doing some of this by going to the companies directly, and it's doing other surveillance by tapping into undersea cables, which the companies don't have any control over. At the end of the day, I think the important point is not that these companies have all the power in the world to protect our privacy. They don't, but they certainly have more power than we do. And they're the ones who have the data. They've been entrusted with it, and they have a responsibility to protect it, and at the very least to let people know how that data is being accessed by the government. And I think it's a good thing that at least some of those companies now are stepping up to that responsibility.
Surveillance of government officials?
Let me take that. Yeah. One other little point on what Jameel was just saying. With regard to AT&T, one of the documents, documents I read that came from Snowden said that AT&T, for example, went to NSA before NSA ever went to AT&T. They were first out of the box to go to NSA, saying, "How about doing some surveillance over here?" Yeah. So the big difference between AT&T and the internet companies.
A lot of that is, I mean, telecoms traditionally were utilities, and a lot of them around the world are government-owned. So it's a very different mindset from the internet companies.
Well, with regard to the Donna's question there on the Hoover, yeah, that's a very good question, actually. Hoover had a lot of power, and that was one of the things that he was able to hold hostage over the officials and so forth. They didn't know what he had in his files there, so he was able to somewhat intimidate a lot of them, and that's why he stayed there so long. I did an article, cover story for Wired magazine last July that looked at the NSA director, at Alexander, as being the most powerful official in the history of American intelligence. And like Hoover, he's been there longer than any other intelligence official in American history. He's been there almost 9 years now. And at the same time, he's the first NSA director to achieve the 4-star rank, the highest rank in the military. And in addition to that, he's not only in charge of the largest intelligence agency in the world, but he's also now in charge of the Cyber Command. So he's not only director of NSA and chief of the CSS, which is the Central Security Service, the military side of NSA. He's now also, under his third hat, commander of U.S. Cyber Command, able to launch cyber wars like the one that they just launched against Iran a few years ago, the Stuxnet attack. So that's a very big danger. And when I wrote the article, it was actually before Snowden's, it appeared at the same time Snowden's revelations came out, but I actually wrote it before that. And I wrote that hardly anybody would ever recognize Alexander because he's such a mysterious figure even within the government. And for one person to have that much power, to eavesdrop on all that information and have that much potential to get everybody's private information is a very dangerous thing, and it's very analogous to Hoover. As a matter of fact, I compared Alexander to Hoover in that article from that Glenn Greenwald wrote about the access to the porn sites and the blackmail and so forth. And that was the same thing that Hoover did, and I mentioned in the article that that came from the person who was the longest-serving FBI director, the threat to use that against Martin Luther King, and now this threat's coming from the longest-serving NSA director. So there are a lot of analogies there.
Rachel, do you want to try to take on the copyright point?
I was afraid that's what I was going to be left with.
Sorry.
As a totally non-intellectual property person. So I've been sitting here sort of trying to think. I will say my initial reaction to the question was that it was an interesting one, but it just doesn't strike me as something that courts are sort of ever going to bite on. So I was kind of trying to think through why that's the case. And I really do say this with the caveat that I do not do intellectual property. So it is possible that
None of us does, so you're
right.
safe there.
Hopefully nobody in this room does. I'll be fine. So there are a couple of things that strike me. One is that I think if there were going to be traction on that kind of argument in this context, these kinds of arguments probably also would have been made in a criminal context as well, right? So in a criminal context, there's the government obtains lots of information. Usually the structure by which it obtains it is more clear. There's a warrant or there's something lower than a warrant, but you sort of, it's been kind of laid out how the government gets to have different kind of information. And then the challenges to the government acquisition of information, I'm not aware that there's ever been an intellectual property challenge. I think it's usually a more straightforward kind of Fourth Amendment challenge. There's some reason that the government wasn't allowed to have that information. One of the other things that strikes me is that I think most copyright challenges or trademark challenges, especially copyright challenges, are where information is being kind of used by someone else for profit, right? Somebody, you own an idea, you own a writing, something like that, and somebody else has kind of taken that and is using it for their own purposes, and especially their own profitable purposes. And so I think the government use of that information wouldn't sort of trigger those same issues. And the other thing, quite honestly, is that courts are so deferential in matters of national security. I think one of the really interesting things that we'll sort of have to wait to see down the line is whether some of what's coming out now about the efficacy of these programs is actually going to make courts a little less deferential and kind of make government officials kind of show their proof a little bit more. But that being said, it's hard to see if you're weighing an intellectual property concern against what the government is stating as national security concerns on the other. My suspicion is that the intellectual property side of things just wouldn't have much traction.
All right. We got 3 people with their hands up way in the back there, so why don't we go to the back of the room and try not to discriminate there, and then we'll move up front again.
Hi, Trevor Schultz. Yeah. So as a professor here at the New School, maybe a question that might concern some students, right, who after hearing all this can only throw their hands in the air and say, like, it's the end of the world. So one response to the situation would be, encryption, right, as many people have suggested. But then also voices for the commodification of these services in the sense of saying that Google and Facebook and all these supposedly free services have just a too high a social cost now, right? So we see all the surveillance, they're supposedly free, they're supposedly convenient. And so there's this, basically the idea would be to say, pay Google $500 a year for what they are making on a user per year, and then have them back off, right? And basically don't have all this sort of commodification and selling to the government. So there's this question of basically privacy as a right versus privacy as a commodity. And I wonder where you stand on that and how you position yourself to that suggestion that many people have made.
Okay. Yeah.
Oh, okay. What do you think happened to Obama? I mean, he ran as a civil libertarian the first time he ran. He said he was a constitutional law professor. He knew something about the Fourth Amendment and so on. And then he gets into power. And, I mean, this isn't the Nixon administration. It isn't Hoover.
I'll do that if you want.
It isn't George W. Bush. This is Obama. Oh, okay. So, and the second part of that question is, why hasn't Congress passed any legislation in response to all of this, the Snowden revelations and so on? I mean, I called my senators, the New York senators, and I don't know whether they've since taken a position, but they're fairly liberal and sensitive. At least they pose themselves as being sensitive to these kind of issues, and they're kind of just sitting on the fence and not really being active here.
Okay, I think we had one more question. Was there?
Hi, my name is Owen. I have no legal affiliations whatsoever. My first question is for Mr. Bamford. I read your book a few years ago, The Puzzle Palace, a really good book. You mentioned that it's fairly easy to take information out of the NSA, and it seems like it still is. I'd just like to see how easy that is. And my second question, if I can ask a second question, you mentioned that there's sometimes too much information coming through to block certain instances like the shoe bomber and 9/11. But I think a lot of these instances, like I've read a lot of information on 9/11, and it was totally planned by this government. So I wouldn't say that there's too much information going on. There's just the government acting surreptitiously and seeing how they can utilize these actions to the best purpose in the future. As we can see, it would lead to two wars that are going on for over a dozen years.
All right, thanks. Rachel, why don't you start, without getting into conspiracy theories, but it's can you just elaborate a little bit on, I mean, this too much information idea. I mean, I'm sure if you posed that question to the government, they would say, well, we're just building faster and faster supercomputers, and give us a year and it'll be fine.
Right, right. Yeah, well, and I think sort of the invocation of 9/11 is really interesting, because there are sort of, taking it away from the, what led to 9/11. A lot of the justification for building these larger databases, sort of building bigger haystacks to find the needle in, has been 9/11, and especially the 9/11 Commission report, which came out in 2004, and said, the dots weren't connected. And that's been used often to justify if the dots weren't connected, we need more dots. And there's really a disconnect between what the commission actually found and kind of what that's being used to justify. So what the commission found was, basically the information that needed to be connected was out there. There were fundamental failures of sharing, especially between the FBI and CIA. And a lot of that was due not to kind of an overly legaled up culture, but just to kind of to a misunderstanding that the agencies didn't understand the extent to which they could share information. And the other piece is that the dots of information that were out there to be connected were largely connected to people who had already been identified as terrorists, to kind of criminal-related acts. So there was visa fraud, there was passport fraud, things like that. So you had these very specific items of information out there that were connected either to people who are already suspected of being terrorists or to these criminal activities, and that's what wasn't being connected. And it is a massive jump from there to where we are now, which is an ingathering of vast amounts of information, quite explicitly about people who aren't suspected of any crime, solely so that those pieces can somehow hopefully be connected at some point down the line.
Okay. I don't know, who wants to take on privacy as a commodity?
I can, or
Go for it.
you sure? Yeah. Well, I'll pipe down afterwards and see if Jameel or Jim wants to add anything else. But there are two things that strike me about the question. I do think it's an interesting question. One is that I've actually been very surprised that companies haven't moved more towards a sort of optional payment model, because there are so many issues that are raised by the fact that basically the information that we're giving companies is their business model. So, I think you see it most explicitly with something like Facebook, that just about every piece of information we're feeding into their system is then monetized in some way. And so it's surprising to me that there's not sort of a, pay for Gmail option that wouldn't scan the content of your emails, a pay for Facebook option that wouldn't then associate, your picture and the things that you're liking with ads that are shown to your friends. That said, I'm not sure that would solve this problem, the sort of problem of government access to information at all. I think these are two maybe connected but separate issues. One is privacy in terms of what companies are doing with the information that you're giving them, and then the other is the government's access to that information. And I don't think, it's interesting, sort of the idea that some of these companies are making money off giving information to the government, but by and large, the government is going to make its arguments, it's going to go to the FISC, it's going to get orders for particular kinds of information, and it's really not going to matter if you have paid Gmail for an account or if you're using it for free. That information is going to be equally vulnerable. And the one other thing that I'll mention is sort of this notion of privacy as a right versus privacy as a commodity. And I'm sure, as some people know, privacy is seen very differently in overseas, and especially in some EU countries. I think Germany is probably one of the countries where it's most explicit that there is very positive, and by positive I don't mean positive sort of rah-rah, but a positive right as opposed to a negative right. So the way the US, and especially the Constitution, defines rights is sort of negative space is carved out against which the government can't intrude, but you don't see, rights to education, right to a job, right to privacy, things like that. To the extent that those rights are articulated, it's through policy, it's through court cases to some extent. Whereas in other countries, in sort of international statements, in German law, there's a very specific kind of right to privacy. It's conceived of as a dignitary right, an autonomy right. And I don't know if that's something, sort of how well that will import to our notions of rights. But I do think that there are important distinctions between kind of US conceptions and some foreign conceptions of privacy.
Maybe I could just interject here for a second, because it's clear that it's good you used Germany as an example, because there the memories of the Stasi or the Nazis still linger far more than anybody here cares about J. Edgar Hoover. And obviously the offenses were much larger there as well. So you know, this is the Facebook generation here in the United States. And I think we have a real political problem because while you all turned out, a lot of people don't care. You know, they feel, oh, the government's not targeting me. I didn't do anything wrong. You know, this is just for my friends to see on Facebook. And if somebody else snoops, who cares? And is this, you know, what do we do with that?
Right. Well, and I think also in part, I think there are a lot of people who are making the same mistake that, in fact, the Supreme Court made, and Jameel alluded to this, that not seeing a distinction between secrecy and privacy, right? So basically what the Supreme Court said is if you haven't kept information secret, you also haven't kept it private. If you have revealed it to one person, you basically reveal it to the world, notwithstanding these kind of quirky distinctions between, say, metadata and content. And I think that that's sort of the error that some people make also when they think about, you know, okay, I've decided to share information with, you know, my friends on Facebook, so who cares if the government sees it? But we do all make decisions as people about who we want to share information with. There's something that I would tell my family that I wouldn't tell friends, or something that I would tell friends that I wouldn't tell acquaintances. And all of those communications, transactions, what have you, are very different from putting that information in the hands of an entity that has prosecutorial and police power. And I think that probably is part of the reason that it is so much more acute in Germany, is, as you say, the abuses were so much greater, and the Stasi was infiltrating itself into every part of society. Whereas I think, you know, Hoover's excesses were, it was targeted at political enemies, it was targeted at members of Congress, and so there probably wasn't as much of a visceral sense that just sort of, you know, neighbors could be affected by it.
We also live, unfortunately, in a culture in which the national security state is glorified, right? All of our media right now, the most popular shows on TV are always shows that glorify the national security state, glorify surveillance, and I think that's quite different in other parts of, not everywhere, but in some other parts of the world, including in Germany, where where there is this real understanding of how these powers can be misused and abused. I wonder whether the fact that Edward Snowden is 29 years old, whether that might have an effect on the so-called Facebook generation. If you watch his videos, if you watch this 12-minute video that he released in the middle of June, it was posted on the Guardian's website. I don't know if that was the original place it was posted, but it's actually an incredible explanation of how all of this information puts political leaders in the position of being able to essentially take over the society. And he calls it turnkey tyranny. He's saying we're not living in a tyranny right now, but we have all these tools that are in place. We have all these databases that can be accessed with the flick of a switch or the press of a button. And anyone who wants to turn this into a tool of tyranny can do it. And that's why he says that's why he did what he did, because he saw that he saw where this road was what was headed. I wonder whether the fact that the messenger is 29 years old might have an effect on the political debate.
One other point on that, the person I interviewed for Wired back in 2012, Bill Benny, he wasn't 29, but he was in his early 60s, I think it is, and he said basically the same thing, and he was a senior NSA official who left NSA after he discovered that NSA was using the system he developed to begin spying domestically, which took a lot of courage. And again, he'd been there for 40 years. But he said virtually the same thing. And he said, I quoted him in Wired magazine as saying, we've come this close to a turnkey totalitarian society, which meant that it's not totalitarian right now, but the mechanism is there, the infrastructure is there to turn the key to make it that way if you had a, Richard Nixon on steroids or something like that. And one other point on talking about Germany and the attitude over there, I think everybody would benefit by seeing that movie, The Lives of Others, which is very dramatic on showing both sides, the innocent victims and the Stasi people who were doing the eavesdropping.
Yeah. I mean, obviously a lot of this is that, these revelations are happening when Barack, trust me, Obama, is in office. And it would have been very different if it was, Bush and Cheney. But that brings up the question, what happened to Obama? Mm-hmm. And where is the Congress? And I don't know who wants to pick that up.
I'll throw something out there, too. I mean, the point is that I think Obama, when he was a candidate, was very different than he is now. When he was a candidate, he was saying, I'm going to vote against giving more power to the NSA, and I'm going to vote against giving immunity to the telecom companies. And then he took John Brennan on as his national security guru, his sort of Rasputin almost. And then everything began changing. And then it became very political, so that if you're looking to the next election, what you know you're going to get in terms of a Republican opponent, they always do the same thing. They're going to argue that the Democrat is weak on terrorism, weak on the military, and weak on national security. So if you're a pragmatic president as opposed to an ideological president, you're going to pull your base with you with health care and the domestic issues, gay rights and all that. But you're going to try to cut the legs off of your Republican opponent as fast and as much as you can. And that's why I think Obama tripled the number of forces in Afghanistan after he became president. During George Bush's entire presidency, 2 terms, he only had one attack, one drone attack in Yemen during 8 years in office. And Obama has turned drones into, he's even killing Americans with drones without any trial. So, and then on NSA and the intelligence community basically turned it over to John Brennan to run it and said, you do what you want, pretty much, I think. So if you get a Republican, he can't argue that you're weak on the military because you just tripled the number of forces in Afghanistan. You could have ended it in 6 months, but you're continuing it for 2 terms. You're expanding the war on terrorism, if you want to call it that, with drones. And you can't say you're weak on national security because you're letting the intelligence community pretty much do whatever they want. So I think it was political to get reelected and certainly not following an ideological
You can't
format.
let us end on that note.
I'm sorry?
You can't let us end on that note. Somebody asked a question about why isn't Congress doing anything. There is a bill in Congress with 100 co-sponsors now called the USA Freedom Act, which would end bulk surveillance under dragnet surveillance under most of the provisions that we've been talking about today. Everybody's looking for leadership from Washington. As we all know, Washington follows; it doesn't lead. If our political representatives understand that we care about these issues, then they will support that bill. They will vote for it. And it would really, it wouldn't solve every problem, but it would actually solve a lot of problems. And there's bipartisan support for it. We came within, 7 votes?
7 votes,
from
yep.
defunding the call records program a couple of months ago. And I think that it's not unrealistic to think that this bill could become law.
Yeah, this is one of the single bipartisan issues right now in Congress, really, is privacy, because of all the revelations that have been coming out, and this is a really good example of it.
And defunding, call that bill or that proposal to defund the metadata program would have gotten 2 votes before the Snowden revelations. It would have gotten Udall and it would have gotten Wyden. And then all of a sudden, post-Snowden, they got between 5 and 7 votes of a majority. So, and I think the momentum is moving in that direction at this point. So that is a positive note to end. If you'd like to end on that.
Well, let's see. We're going to do one quick round here. We've got 2 hands over there, and we'll go this gentleman over here. Very short questions. I didn't call on you, did I? Okay, I'm sorry. Okay, then very quick, and then we're going to move on.
So you spoke about how whistleblowers who go through proper channels have either gotten nowhere or actually in jail. And then I don't know if you spoke about this, I was a little bit late, but I can't remember if it was Alexander or Clapper, but one of them straight up lied to the Intelligence Committee and nothing came of that. And then you spoke about the Jones case.
Okay, that's enough. We have to move on.
Okay, all right. So
next
the question then is there any point in fighting these issues through traditional legislative and political means, or do you think that radical direct action, such as Edward Snowden leaking, is required to dismantle these structures?
Okay, got it. Then next to you.
Hi, I'm a journalist, and I'm also an immigrant with non-resident alien status. Can you hear me? Yeah. So I was wondering, what data should I expect the government to be looking at or have access to when assessing or whether or not to grant me a more permanent visa? And then more in general, what...
That's just one question. Okay. We got to go fast. Okay.
Hi. Can you hear me? Yeah.
Yes.
My name's Alex Urbellis. I'm an information security attorney, and I would just like to take the opportunity to push back a little bit to the panel and suggest that I think that we also, all of us here, enjoy some measure of culpability in allowing these programs to exist because, as the panel has rightly pointed out, the legal infrastructures for these programs have been put in place and have been put in place for a number of years. We're dealing with Section 215, Section 702 of the FISA Amendments Act. These have been ratified by NSA, Office of General Counsel, CIA, Office of General Counsel, the White House Counsel's Office, independent Article 3 judges. I think it's very difficult to contest that these aren't legal problems. And if the answer to that is yes, then I think piggybacking on the other question, isn't the answer moving forward, more of a political process than it would be a legal process?
Okay, then last question here.
Jerry Spivak, Values Caucus of the United Nations. I haven't heard anyone talking about positive values of the NSA program. And since it's an intelligence agency, it seems as if it should be a resource for America. And so I'm wondering what would happen if we just made all of the data available to sociologists and to people who want to write their memoirs, so that they can look up things and know exactly and do research and do something valuable with this data.
Right. Thank you. Okay, well, let's just go down the road. Last word from each of our panelists.
Well, just in response to the question from over there, there's legal and then there's legal. There are some of these programs, as you note, are on the books. There are laws on the books. They result from things that Congress passed that we all saw on the books. But the fact that Congress passed it doesn't mean that it's constitutional, right? There's supposed to be a constitutional check at the end of the process, and these arguments about state secrets and standing have insulated these programs from that kind of scrutiny. So that's not to say that we don't share some of the blame for having let this happen, but there's a kind of systemic failure as well.
So I guess just to make a few quick points, I think the other piece to follow up on Jameel's point is that members of Congress have now been saying we literally didn't have all the information in front of us when we approved some of these laws, right? If we had known then what we knew now, we wouldn't have approved this. Or you have somebody like Representative Sensenbrenner saying, I authored the Patriot Act and I didn't mean for it to be used this way. So I think that there are those issues. With respect to this sort of whistleblower clapper question, I think it's a combination. I think there's no question that we wouldn't be having this debate. And as Jim said, these votes wouldn't be taking place in Congress without the Snowden disclosures. But I also think that there's real change to be made through the system now that this information is becoming known, and there really is momentum that I think is very, very worth building on. And my one last comment I'll say to the sociologist question, there have been at least one or two reports of defendants in criminal cases trying to prove an alibi and saying, you know what, I know who has the information about where I was on a certain date. It's the NSA, and trying to get the information that way. So I like that idea in some limited circumstances.
Jim, you get last word.
Well, yeah, on the whistleblowers, I don't think there's been enough really positive comments giving towards whistleblowers. They really risk a lot. I've dealt with whistleblowers all my life. I couldn't write books without whistleblowers. And they really risk a lot. There was a comment made earlier about Snowden in Russia, for example. Snowden is in Russia because of the U.S. government. It's not in Russia because of Snowden. Snowden had a through ticket from Hong Kong to Ecuador, and after he left Hong Kong, the U.S. cut off his passport. So he was stuck in the stuck in the airport for a month or more because he had no travel documents. That's why he's in. And then the U.S. government decided that the president of Bolivia might have had him on his plane, and they actually forced the plane carrying the president of Bolivia down. So he's in Russia because he has no other choice but being in Russia. But that wasn't his goal when he started out. So in terms of whistleblowers, I give them a lot of credit, and I think they deserve a lot of thanks from the American public for doing these types of things. And on the gentleman's question on the positive aspects of NSA, yes, the place in Bluffdale, if I ever, my computer ever crashes, I hope that I could call up Bluffdale and say, hey, you know, go to room 205 and look up my computer here. It could perform a very good service, or if I lose my phone and can't get phone numbers back, you know.
All right, let me first thank the New School for convening all this. Thank you all for joining us, and thank you to our panelists.